Hello, welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata. I am joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Hey, what's up, guys? Thanks for joining us. So, big day today. Another big day in the Karen Reed drama that just keeps on going. And today, the defense had filed a motion to dismiss, and they supplemented it a few times as affidavits were prepared by Jackson and Yannetti, wherein they kept describing conversations that they were having with jurors that had been impaneled. And every juror that they have spoken with has stated that, hey, we came to a verdict on counts 1 and 3, and it was not guilty. And we didn't know what to do. So we're here on this defense motion to dismiss, and it is basically them saying, look, we're asking you to dismiss counts 1 and 3 because the jury did, in fact, reach unanimous verdicts on those 2 counts, even though they forgot to tell us. So that's kind of where we're at right now. And we're waiting for Josh to get here. He'll get here. He said he'd be 12:45-ish. He's a busy boy like I am, so I know he was on Court TV earlier this morning. So when he gets here, we will pull him in. So what are your thoughts on this, Bay?
I mean, I honestly don't have a lot of faith, at least not that the judge is going to find. There he is.
Hey, there he is. Oh,
hey, sorry.
Hey, there he is.
So I had to restart. And
you were right on time, my brother. You are right on time. Josh, I don't know if you've ever met my much brighter, much more attractive partner, my wife, Allison, fellow criminal defense attorney, Josh Shiffer.
There's always got to be someone stronger and smarter and better than the public fit. That just has
obviously.
I tell people regularly, I've not written anything original in decades and basically am illiterate. I how to do the talky part, not do the righty part.
Yeah, you are definitely good at the talky. If you guys are not familiar with Josh Shiffer, brilliant lawyer, criminal defense guy. You guys had your practice is very similar to Allison and I. We did a little bit of everything. Certainly the focus was on criminal defense, but certainly handled our fair share of civil stuff.
Best part about this gig, and I tell people about that when they're talking about getting into the law, and they have these fantasies and dreams, and those dreams can be very real. You just have to be the practitioner that wants that, and you can live the same life that y'all do, or that I do, or my partners do. It's just not for everyone. You've got to have a high risk tolerance. Because face it, we're professional gamblers. I give credit to people who owe me money and they are admitted or acknowledged alleged criminals. And some of them are definitely criminals. And I give them credit. And then on the civil end, I'm betting my time, effort, and huge financial investment that a random person isn't going to blow up my case before I can get it to the right spot. It is super exciting, but emotionally, it's something.
Oh man!
And I really am like an actual gambler as well. So, other than in the law, but it's very true. I mean, you've got to know when to hold them and know
when to fold them.
It's that risk assessment is such a core competence that every litigator needs. It's not can I win? I can win anything. Juries are the most brilliant idiots in the world, and any lawyer that's worth one damn has lost cases they should have won and won cases they should have lost.
Yep.
It's all about risk assessment and finding out the strengths of the people that are up against you. And in most of my cases, it's the state, but my partner is exclusively civil. And really figuring out how do I educate my client as to what risks are worth pursuing and what not, and figuring out what pathway. And sometimes you get a long time to make those decisions. very often we're making those decisions on the fly while under covering fire, or someone's not covering fire.
That is the gospel, man. That is the gospel. I mean, like, thinking on your feet is probably one of our most critical skills in terms of doing what we do, especially during a trial. Because I mean, no trial ever goes as planned. We see it every day.
The first step is, you spend all this time planning, knowing that immediately upon walking in, your plan's going to change. Your plan,
exactly. Shit's going to go sideways.
Yeah, and what's your adjustment? What's your response? What's your twist? Because they're going to throw their biggest ball straight at your head. Right. And man, you can try to catch it, you can try to duck it, but you got to respond and you got to throw back. And it's what makes this practice so fun and exciting and rewarding. It's also what kills you early, means that we all have drug, alcohol, mental health problems because it's rife in this industry, no matter from the low end to the top end. There's a lot of struggling people in practicing law. But the rewards personally and professionally and finance, man, I can't imagine doing anything else. I get to hang around with such smart people, and the stories. You can't write fiction as good as just go do 10 intakes.
You ain't never lied, dude.
Dude, go do 10 intakes and tell me you don't have enough source material for Shakespeare's next great play.
Exactly.
You see stuff that's which is what brings us here. Because, man, y'all ever seen something like this?
Man, I mean, we had a case in Omaha that was pretty insane. It was closer more to the Delphi thing, but this case is unbelievable. So, which brings me, before we jump in, and I've got it up, Karen's walking into the courtroom. What is your guess on what's going to happen today? So,
when I analyzed the situation, just to catch everybody up, and I literally just explained this to a judge here locally yesterday, and she was in wrath. So here's what's happening. Judge has made a mistake by not fulfilling the duty that basically everyone says she should have. But is that error causing a harm? Is that error and harm something that is meaningful, or is it reversible, or is it going to fundamentally impact somebody's rights? I believe that it does, because absent her error in failing to record the decisions that were apparently made, and I'm operating on the belief that the jury did agree on 1 and 3. It just never got recorded or polled. And had they been asked, they would have said, no, we've agreed to acquit on 1 and 3.
Yep.
With that being the case, I believe it's going to be one of these where behind the scenes and between the lines, the judge has told the Commonwealth, y'all know how to keep this going. Don't make me do the thing I have to do. Right. Why don't you guys take care of this problem now?
Right. Moot it out.
Yep. And we can have this hearing, and the Commonwealth can get up there and say, oh, look, we're doing our job. But the result, and I just don't know about the pathway. The result, I don't believe the Commonwealth brings back charges 1 and 3 in whatever future retrial. I believe this sets up for a plea where at some point Karen has to have the Band-Aid ripped off, come to Jesus meet and go, listen, the stuff that's uncontroverted involves some probable criminal liability.
Right.
It just is. If you break it down into individual claims, there's some criminal liability there, whether it's a form of DUI, a form of leading scene of an accident, a form of there is stuff they can get her on.
Yes.
And the state, I believe, realizes how bad they are positioned. And at some juncture, they have to give a resolution to Jackson and Yannetti that they have to bring all offers to the client. That's one of the things the other side can actually make you do is convey an offer. If you don't convey an offer, that's just malpractice. You can tell them this offer sucks. Here it is.
Right.
But you must convey that offer. And if the state or the Commonwealth comes back and gives her something that is eminently reasonable, preserves whatever is most important to her, it'd be malpractice not to recommend her to take it, just because you have that obligation as her lawyer to say, listen, no, they can't get you on murders and manslaughter. No. but they sure can get you on some driving and some drinking and some not report. So let's talk about straight probation, first offender, slap, tickle. The state does a reduction justified because of problems with their investigation and the unreliability of issues that they can't go back and fix. And due to time and resource, we've decided to make a very generous plea offer that Ms. Reed should accept. And think about the hundreds of thousands of dollars, if not millions of dollars, that saves.
And just the nightmare that this trial became, like just finally kind of like stomping it out. Like everything that's gone on collaterally with this thing has been like a nightmare.
Oh yeah.
You know, because I've been that guy where like I'm always on the fence with cases, always. Like I've tried so many cases where, you know, maybe we're drinking the Kool-Aid and we're like, wow, we put on a hell of a defense. I don't even know if my guy did it or not.
I've like, swung and missed big, man.
And it's like, but this case, I'm like both things kind of seem implausible to me. Like both the theories, and I'm always telling people, I'm like, that's all these are. The state wasn't there. The defense wasn't there. The cops weren't there. No one was there when this thing went down. So all they could do is come with educated guesses as to what they think happened. And that's all it is. And like, what does the evidence fit in terms of which theory better? And that's kind of where you land. But man, it's like in this case.
And it's weird because remember, the defense, in most defenses, you may have some theories you're going to suggest and some alternatives you're going to suggest, but the affirmative defense, where she is getting up and claiming the basic conspiracy theory, we all looked at it like, man, that's a bold choice there, Cotton. Hey, defense, you're giving the jury something to latch onto. Juries like promises getting fulfilled. That's one of the best arguments.
No doubt.
Is, hey, they promised you that, and we didn't see any of it. Man, defense has to do that too.
Hold on, we'll move you over to the other side, Josh.
Yeah. By wedding them to that story, it was great for the first trial. May not be as good for a second trial.
Yeah, and I was saying it as we were live streaming this trial. Like I kept telling Allison, I would have, like, if I knew that I had the two independent witnesses that had been hired by the DOJ. Man, they were like pennies from heaven, man. Like you can't get a better situation than getting two hired guns that are not hired guns to come in and their testimony supports your position. I would have abandoned the whole third party culprit bullshit and laid into that completely.
And you would have had damn good reason to do it too, because those opportunities don't come, man. You practice this stuff. You don't get gold nuggets like that.
No, and that's my issue with it. I honestly don't believe there's any evidence that she struck the guy. I mean, yeah, evidence that she was drinking and driving for sure. But, you know, but that doesn't mean you don't analyze the risk. Like you said, if things are all what it seems, now I forget, so don't hold me. It's either like what, 8-4, 9-3 for not manslaughter, but the lesser on manslaughter, right? Which,
I think it was involuntary. Right?
Involuntary manslaughter, which still gets you a significant amount of time. So if they'd give her something lesser, and obviously if they'd give probation, I mean, I think that's been the problem all along, is that this whole defense team has been dead set on proving her factual innocence.
And you're 100% right that the defense became proving innocence, which is hard. But then it also, that changes the dynamic, just like you're talking about, with how the case was actually brought, because when the defense goes that hard, the state gets to ramp it up, which they do.
You guys can hear it?
Yeah. It's kind of soft.
It is.
Yeah, it sounds like shit.
Come on, Judge Bev, let's get a good microphone feed on. And I'm so glad YSL's off today, because y'all got to be watching that stuff on Monday morning.
What a case.
Down there. I don't even have a case. I'm going to go down there. I want to see Woody. Because that made just explode.
I love him.
Woody.
What a character. What a character.
Oh, this isn't good, babe.
Yeah, let's get some better feed on the audio there, Court.
I'm checking Court TV.
if this audio doesn't get any better, I'm going to have to check a different feed, maybe.
I'm checking for TV.
There's not one interpretation, just one court.
I just want to make sure I hear.
There are two central issues that are raised by the motion to dismiss and the supplemental affidavit.
Is this long crying?
First
Bob?
of them is
No.
whether or not there's strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized through a vote or to a polling at a specific court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts. The legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed.
It's just as bad on court TV.
Yeah, they have no mic in front of them.
It's like a pool feed.
Judge, I will
I'm going to try the judge's thing.
a proposal to the Your Honor that's close to the procedural pathway used by the judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince the attorney's office that the jury we teach it. We system it was a unanimous decision on 2 of the 3 counts. Was in fact on the 3rd count. Was count 2.
He needs to say unanimous a few more times.
The second of the leading issues that I want to address, and they both together center on the double jeopardy clause, is unique history, and it's discouraging prohibiting second trials when there's any rationale that justify verdict of the first trial and further continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not in the case, evidence that was known to Your Honor at the time that you ordered that they be spared in the order of this trial, evidence known to Mr. Valley of the prosecution or the defense, that in fact the note they wrote to Your Honor after.
Yeah, this isn't me. This is the feed. They don't have any mic setups in there.
I think this is the pool feed because that courtroom's so on broadcast about it, and it's that.
Yes, covered all 3 counts, therefore would lead to a mistrial declaration. Or 2, that the impasse was on one count with multiple lesser charges. It did not encompass counts. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored the note to either the counsels. But the issue now, and again, it's in the context of the such a historic and important clause. It was enacted by a family law to give them some protection against the sovereign.
All right, hold on. This is what I'm going to do. I'm going to switch over to Austin 10, their feed. See if it's any better. People are saying it. We'll find out.
Yeah, they can put filters on it.
Of having to prove to a second jury.
Do you guys think that sounds better?
First jury, which is that they were not guilty.
Whose feed is that, Allie?
No
Can
sound.
you guys hear?
I don't have sound on that one.
I don't have sound.
See, this is my issue. I don't know. This is my issue. I don't know how to share the audio.
Let me just put mine up. Can you guys hear that?
Embrace the fact that these are now facts. Yes, they come.
All right, I'm going to rewind it just a hair to about here.
What was in the jury's mind? What was in their mind when they authored a note to the court? Neither did counsel. But the issue now,
that's better.
It's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign, at that point the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct, 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury? And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all three counts when four jurors are saying to you through counsel they were not, and a fifth juror.
And he just wants to be like, Judge, you broke this. This is your fault. This is like, it's a delicate pathway to deliver. He's trying to call her out without insulting her.
Right. He's trying to do it gently.
Yeah. For folks that are figuring out the dynamic, the core issue is that the judge didn't do their job the way that the judges are trained, and that the other judges would say, hey, man, you needed to do this part. And normally it doesn't get this much scrutiny. But in this case, man, if there was a time to make sure you belt and suspended and then went to the tailor and made sure they sewed it on to you, this is that case. And she didn't do it. She didn't do it. I mean, to me, if first and foremost, to go back to your original point, if I'm the Commonwealth, I'm mooting it. I'm getting rid of counts 1 and 3 because it's the right thing to do. I don't care what side of this you were on. No one thought that they met the intent element for second degree murder. No one. Like, I don't care. Like, because they didn't. Undisputed jury has now is as on the record as they can, refuting the state, and it should there be the obligation of the state to listen to a jury. Remember, that's what they always say after trials. We respect the ruling of the jury. Right, exactly. And like, the only argument that I can see the Commonwealth coming that might have legs, at least as far as Canoni is concerned, is waiver. That they failed to object, that they should have said something. They waived the issue. We'll see. Like, that's kind of where I've been laying my hat.
Well, they did have some law about not saying nothing is not the same as waiver, and whether or not she literally didn't give them the option technically before she dismissed. We all know they had time to say something right afterwards, and maybe should have, but technically she had already declared a mistrial. And then for anyone who's wondering, this is a local criminal defense attorney. I think he also specializes a lot in appellate work as well, that has been retained to handle this portion of the proceedings.
And that's because more likely than not, Jackson and Yannetti are going to have to testify, or theoretically they will have to testify. Absolutely. And it's good to belt and suspender with someone who, with this guy's gravitas, I bet his name is known by the people that look at reviewing these things. 100%.
Right.
100%. All right, let's go.
but it doesn't mean that there's not some.
You're sure the volume's all the way up, right, babe?
I'm boosting it, yeah.
Integrate those facts into Your Honor's decision making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here, what we know is that 4 jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend that the voicemail left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil her the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of 1 juror from Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people that go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a new prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form, of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are without point. I mean, I've done this for 52 years. So procedures important, inform, sometimes discuss. And it's the recognition that double jeopardy is necessary. For instance, as I mentioned, all of the courts put a heavy burden on the prosecutor to justify.
And now there's an echo.
To justify the prosecution. Ordinarily, I'm used to speech as a defense counsel. I'm used to having an affirmative obligation to lay out those area. So they put it on the prosecutor, and I will get to the cases that support that, what I call the central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, this ring goes to trial again? Or is the default instead that the prosecution simply cannot again be prosecuted when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court. And it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matthew extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, it's important.
I love a good history lesson, but this trial lawyers start losing trial lawyers. Like, the judge knows this stuff.
That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death. The Sanaya, which was arrested and survived.
All right, pause it, babe.
In a lengthy opinion, over 100 pages, said bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago in the case where Your Honor.
All right, so I've got it up on the Zoom, but I can't rewind.
So, and you can't pause, right?
Can't pause.
Does it sound so much better? Did you try Court TV? I mean, Long Crime again?
I can't. I could try.
Closing the door.
I think
It
we
does
should try.
sound. It sounds moderately better on Zoom, but it doesn't sound great.
I think patch us into Zoom while we figure it out.
Patch us into Zoom.
Like share Zoom, then you keep looking to see if you can find it better on YouTube.
Consistent with the column.
I don't know where it is.
Tonight, consistent with the Supreme Court decision in Remmer. And
Okay.
take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from improper contact with a third party. and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process.
All right, let me see.
We're hearing it, so just shush.
But if all of them tell the court, we made a final decision, we never went back like the Bluford case or to re-examine it. It's not an immediate decision. It was a final decision. All of our impasse was about count 2 and the multi-progressive included. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath.
I do like this angle.
Yet they convinced by these.
The judge's angle.
Yeah, I do like this.
Case, and I'm not being critical of the DA, but I've done this for a long time.
I've done this
in our system of justice. People say it's not perfect, but it's the best that the world has. You know, this to me is hallowed ground in a courthouse named after someone I was a friend who I deeply respected. I want the prosecutor to get the facts in the best way we can at this point in the case, which is through your honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal with implications to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of mistrial. Now, manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, we believe there was a vote. There's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 instructions. And this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count.
The burden of proof argument. That's a good one.
Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, was one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity. Says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth.
Not that burden of proof.
Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision. This is the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. It was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with the jury of fact. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact the rule of criminal procedure, and the defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, or are we going to put the burden on the prosecutor to have advised us that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. Everybody focused on Roth, Juvenile, Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And Rule 27B, that you were not advised of, we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
Do I hear Justice Kitty?
Justice Kitty. There's some meowing going on there. She's getting needy.
Provided a viable option.
She likes Marty Weinberg. Give me a minute. You guys do know he is literally a legendary guy.
Wait for it. Legendary.
Seriously.
Not only puts the heavy burden on the prosecutor to set of guidelines, which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them two principles guiding our review of manifest necessity. One is counsel must have been given, the word must implies it as a mandatory, as an imperative. Counsel must have been given full up to be heard. And I'll address that second. And quote, the trial judge must have given careful consideration to alternatives.
And then the judge on the judge's failure. We listen to that.
Legal intelligence. And we contend respectfully for a variety of reasons that neither of those two guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of Your Honor taking argument from counsel regarding the morning note, and the prosecutor didn't want a 2E instruction. The defense counsel did. Your Honor elected to give a 2E instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Giannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel would be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they want. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, the Cole, the Appeals Court in a case, Commonwealth versus Oregon, that we cited, in light of the importance to the defendant's right to be free of exposure to second jeopardy, the burden of justifying a mistrial rests on the prosecutor. So again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in the Cole did. It's on the Commonwealth to have advised you, Judge. So this was a case that really comes down to whether or not there can be deference to a judicial ruling when it was made without meeting the criteria of full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, in fact at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not in an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I suspect, in a search for justice in this courthouse, but we don't want somebody who's found innocent wants to face the trial for the very same. That's the whole principle, the centrality of double jeopardy. Justice Douglas's last words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion. Either allows the defense lawyers to supplement the
the declarations, juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. And this Reed was acquitted. Bring the jury to Judge Shiffer from them. Thank you. It's the right thing to do. Thank you very much.
All right, thank you.
Is it harmless? Is double jeopardy harmless?
We're getting the close up of Lally.
I was gonna say, Lally. Now, does he stand up and do the right thing? I'm gonna say no. I'm gonna say no.
Not a chance.
Your Commonwealth would have request that the defendant's motion to dismiss be denied, as there was not a verdict returned. Counsel had more than adequate opportunity to be heard and object to the declaration of mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regards to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who was declared repeatedly to the court that they're in an impasse. So if you simply put, Rule 27B just does not apply. When it comes to those respective points, the jury in this case, number one, did not return a verdict. Number two, counsel had ample opportunity to object to the declaration of mistrial. And three, that the mistrial was declared out of clear manifest necessity, which the court in case law has repeatedly stated as the typical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries, of cases. And counsel and the defendant in the memorandum and an argument does quite a twisting of logic into sort of a parental in order to have the circumstances of this case fit into the precedent. And there's a reason for that, because there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's the case in which following jury deliberations and defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation room in which the verdict slip was marked as not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked. The not guilty finding on the verdict slips does not contravene or overrule of the verdict as it is applied in open court. And quoting from that case, and I think it's directly applicable to what's been provided to the court so far, it states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, in contravention to that case law, in a juvenile, in Bluford, in Roth, in Ray, in all of the cases over the decades and the centuries dealing with this. Bluford itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes from Commonwealth versus Carnes as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave that stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth would submit, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of a lengthy trial and to review the many communications that the jury submitted to the court, which Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertains to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality, twice within that note, as it pertains to exactly what they were studying. When it comes to what they were communicating and reporting to be at an impasse in regards, they referred to it as the charges multiple. Whatever point jurors may have felt, and the other thing I would think about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law said. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether they be personal, professional, who they've talked to, what they've talked about, how those things have formulated in their mind, the intense pressure that they felt just looking at the affidavit from the one juror in regards to the impoundment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Giannetti was asking for a Tuli Rodriguez. And understanding that asking for a Tuli Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done or that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, these are Mr. Giannetti's own words, on both occasions, indicated that from that, or argued for Tuli Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopefully deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about for mistrial at those particular points, or at least leading down. Now, as far And this is also, again, as I stated, backed by the case law. Ray versus Commonwealth states, counsel's request for a Tulio Rodriguez instruction permits, quote, the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. Commonwealth versus Pereira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case in this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight or measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of a manifest necessity is a deadlock jury or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Yannetti during his arguments for the Tulio Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz.
Now he's fishing. He's never the inference that people cook the jury.
Has never been required, and that goes to the Hoover decision from the United States Supreme Court to the Supreme Judicial Court of this Commonwealth. That there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those.
Don't worry, Judge,
whether or not they have a vote or whether or not they have a partial verdict. And I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those were the two boxes to be checked. So in those instances, it may be permissible for the court to inquire and poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing for the court to inquire into those types of scenarios. So I guess the defendant's position is the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know that there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes.
She inquires if they reach a unanimous verdict on 1, 2, and 3. She doesn't keep 2 out.
Were there any that you did reach unanimous verdict?
Right.
Yes, in fact, there are. Great.
Yes, 2 of them.
This is pretty facetious there, buddy. You're dragging, Lally.
Yeah.
Deliberately, as far as the language that was used, declared themselves to be on an impasse on 3 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity.
Yeah, but it was stuck on 2, 1, and 3 appeared fine.
No alternative other than to declare a mistrial. And it's clear from the language of the jury's communications report, and it's clear from the case law and the rules and the law itself as far as what the court can do.
I love the clear. Clearly.
Hey, man, you know the state always speaks in definitives.
Of asking for creation of new law, again, sort of special or deferential treatment to this case or this defendant. The 2 areas in which the court can make post-trial inquiry have to do with some sort of bias if there is an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance sorry, one moment.
Allie, is that a rhetorical question? That's what the state does all the time.
Yeah.
All
Selective recall, selective usage, selective memory. They love it. They're the man. Because if it feeds them, they're all for it. It's just,
the kings of revisionist history.
absolutely.
Specifically within those cases, what the court states, which is obviously binding on your honor.
And what he's really doing, everybody, is he's trying to show, hey, Judge, if you want to rule for us, here's some cool words to use. Here's some cool theories that, and for all I know, they make sense, right, Judge? You agree with it. You lift what I'm arguing and use that to justify my position.
Exactly what
you need to make up your own excuse why you didn't do what judges should have.
By those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles, barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry.
Totally irrelevant, not on point. None of that is happening.
That the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for that. Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror calls you, this still does not allow for counsel or the court to then have these conversations with these jurors that delve into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, and I'll sort of condense a quote from Commonwealth versus Rucker. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the liability of any such partial verdict returns is too low to warrant such an approach to salvaging some partial result from a deadlock jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what.
I wouldn't say prohibited. I don't think he made any place where it was prohibited.
Anyone
Me either.
To, try someone who has been acquitted by a jury of their peers or retry that at the same time. That's not what happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of mistrial. And the court did absolutely nothing wrong in finding a manifest necessity.
Oh, see? Judge did nothing wrong, Josh.
He did. And I get it. It's track. Hey, Judge, rule with me. But it also highlights, Judge, you made this mistake. And that's where the appellate position comes from.
Marty's got that sweet little tuft of hair in the back sticking up.
And then I'm like, man, is that the baby pony out there? Even I had the 1-inch ponytail when I had some hair.
Commonwealth versus a juvenile. The juvenile versus Commonwealth. 392, 1952, 1954. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they scourged any kind of court questions as to where the jury stood on lesser included. That's the principle of Commonwealth v. Ross. The other case that Mr. Lavin, that case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser included. And because of the fear that a court's mere question could have a kind of domino effect, coercing jurors to reach compromises as to lesser included, the court prohibited such questioning as to lesser included. But the court distinguished throughout this lengthy SJC our case. We're not dealing with one count vertically with multiple charges. We're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. The juvenile, weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Buford, the Supreme Court case, where there was a statement to the court that we'd reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they would. They needed to decide all the different allegations with it. And they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached 2 decisions, 2 general verdicts, but we're at an impasse on a 3rd one. The Commonwealth talked about the risk that some of the jurors might be exposed to media, and it's certainly more than true in the Samantha case, where they had just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. If you're an experienced jurist, I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lowry's citation to Moore, the discomfort, and the rules that say jurors should not be.
We lose it?
Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally is concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted a mistrial, he could have asked for a mistrial. The Honor would, of course, have the discretion to deny it.
What the fuck?
45 days of deliberation. He asked for a Tui instruction. And it was inferred by a Tui or Rodriguez instruction in the state court. Tui, I think, is a 19th century federal case, is that you have hope. When you're asking for the Tui instruction, my experience, usually the prosecutor is confident in the jury that wants the Tui instruction to try to get the majority to overcome the minority to get to its guilty verdict. Here you have the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations. So there's no answer, and the Ray case does not say that when you ask for a Tui instruction, you are really asking for something more than the Tui instruction. Tui means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that will be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination for the respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution. Because that would be a horror to make her convince 24 jurors of her innocence. A second 12 when she's already convinced the first 12. Thank you, Judge.
Thank you. Any response, Mr. Lally, or are you all set?
No, thank you.
Okay. All right. Thank you very much. I'll take this under advisement.
Boom.
That's it.
Sure. Thank you.
Is she gonna cut the feed?
Probably.
That's what I'm waiting. That she cuts it quickly.
Thank you very much.
She
Yeah.
gone. All right.
Done. No questions. No more discussion. So, what'd you think, man?
I think I think Marty's got the right argument. You know, I mean, if we're just talking about the pursuit of justice, I mean, she's got to call him in, whether it's in camera without attorneys there, whatever the case may be. I think that in her position that she needs to talk to these jurors just to find out, you know, I mean,
I think that her getting exposed to those jurors though, then creates a whole raft of problems. I really think that after that hearing, there's a back channel to the Commonwealth telling Lally, don't make me write the order.
Right.
Because they're cognizant that orders get appealed and then they go up to appellate courts. That's where law comes from. Good, bad, ugly, and different. And there are thousands of lawyers who regret the appeal that they were part of that then created some ruling that is now remembered forever for its good or bad. You know, in really busy, like when DUI was really developing, 10 or 20 years ago, people were collaborating. Don't appeal that issue, man. We don't want them to come back bad on that. Do it under this case. This is a much more rare and unique setup. I don't think anybody's really had a case where the judge failed to follow up with something that was important, that the jury didn't stand up a little bit more and say, hey, well, we do have an agreement, but that gets to our critique of jury instructions, which are a disaster in all 50 states. Jury instructions are one of the biggest problems we have in the court system.
No question.
How many of y'all read the instruction manuals? Really, that's what jury instructions are. They're instruction manuals written by lawyers about complicated. They're brutal. You can't understand them after you've read them. And I went to law school.
Exactly. They're brutal.
It's like you got your taxes for the first time and being like, I don't even speak this language. So the jurors, there's probably a line in there about, hey, jurors, you got to go, tell us if this and this is the proper language. And they fight about semantics so carefully because that's where these arguments come out of.
Exactly.
And I think that Marty made a really good argument because, hey, Judge, it's your fault we're here, but we obviously can't just blame you face up.
Right.
What we've got is we have a problem that no one asked for, that was unthought of, even though there were best practices we should have followed. And guess what? The defense, they should have noticed in a perfect world, should have noticed that there were questions, should have locked that down. That's why you create a record. That's a foul on them.
Yeah.
It's a foul on the state for not inquiring. Hey, you sure you didn't breach anything on one of our charges or give us some evidence? The state, because remember, state has a theory, but that theory isn't necessarily what a jury approves. Obviously, the jury rejected big chunks of the state's theory, uncontroverted. My ruling issue comes down to, is this some sort of harmless error? The answer to that is no.
No.
It is not something that this is an error that dramatically affected the rulings that came out of this trial, and that it would impact any future trial or retrial for the defendant. And the defendant's civil and criminal rights trump the interests of the state in these issues. Better to let 1,000 guilty people go free than convict the innocent.
100%. And it's to me, it's tantamount to double jeopody. I mean, if she does it without even inquiring, if she takes the easy route and just says, look, I'll deal with this down the road. I'm kicking it. I feel the defense waived it.
Yeah.
And I'm not even going to get to the merits of it.
For her to do. You guys got to understand, the path of least resistance is, hey, that sucked. State, let's just do this again. Make sure everybody gets their shot. Like that's an easy, idiot-proof route, because then whose problem it is? The Court of Appeals after the next trial. And the judge like, hey, man, I just had to make sure that we got a trial in for somebody else to review.
But your initial point is the correct answer for this. There has to be some back channel meetings. She's got to get Lally on the phone and be like, look, dude, there's an easy way for me not to write this order, and that's just come out, declare that you're dropping 1 and 3, that you're going after count 2, and that's it.
And that's the oath. Like if you go read at least the prosecutor's oath in Georgia, and I'm almost certain it's got to be almost the exact same up there. It's not go get convictions. Your job isn't go get convictions. Your job is to go do justice. Get the appropriate accountability. If you know they didn't murder someone, you shouldn't pursue murder.
Exactly.
If you have reasonable doubt that charge, and as a charging prosecutor, is a reach because you don't believe or don't have reason to believe you have beyond a reasonable doubt strongly, it's your obligation to dismiss that, because it's not about go get convictions. That's why the state gets the benefit of charge number 2, which has all the lesser includeds.
Exactly.
Because there's a bunch of different check the box. Because no, when you're charged by the state, they don't charge you with one thing. This is charged in the alternative with a whole menu of choices laid out by the state with the assistance of the court of these are the ways Karen Reed can be guilty. The pathway is clear.
Right.
It's not as clear as here's how you say not guilty. Because
and this is not an acquittal first state, meaning that they had to acquit her on the murder in order to get to the second one. And it's like I don't know if you were watching when she went through and read the instructions of the jurors, but man, to your point earlier, the instructions as to how to work the verdict slips they were like a nightmare. It's like you said, it's like
It's teaching your grandparents how to email all over again. It's so foreign to most people. Like we teach civics in what, like 4th grade? And that's really the last time a lot of people hear about how this functions. The words used are not written at a 3rd grade level.
No, they are not. They're written at a law degree level, and because they're written by lawyers.
Yeah, and they matter. And they met the difference between shall and may. We hear about that. To most people, it's like whatever, shall and may. To lawyers, the whole
everything
from shall or may. That's your existence getting up in the morning like
everything.
Shall or is it a may? Because
right.
that's whether it's operative, required by a judge. And if there was a very clear ruling, the judge shall do da-da-da-da-da. That's the easy way to upset a ruling in the future based on a court of appeals. Because court of appeals doesn't care about the emotions the way that the trial court does.
Exactly.
The court of appeals is supposed to be dispassionate and removed and consider the process, not for this client as much as the process for all people. Everybody of all stripes, no matter where and when it comes. And it's why the worst cases make the best law.
No question.
Take something to go up, have an appeal, do it. Remember, there's a lot of states, Georgia included, and I believe Massachusetts is one of them, that if you file a really good appeal, the answer isn't a responsive brief from the state. It's a phone call about repleading your client.
Exactly.
And they'll go, oh, Mr. I saw your appeal. You make some great points there, and I know where that guy's set to rot and die in prison. If we redo this with a get out of jail on probation and not have to go through the appeal, would that satisfy your client? Your client gives 0 Fs about the state of the law in your
exactly.
They want to get out.
Wait, am I getting out?
Yeah,
I'm good.
They're like, Mr. Shiffer, I don't give a what you do. Get me out of here. I'll sign it.
Exactly.
I'll testify whatever the hell you want. Am I getting out of here? That's exactly how they go, and they steal the appeal from the rest of the state and the rest of the nation because they recognize, holy crap, if we actually give this to a bunch of court of appeal judges, they could come out with some crazy ass rule that screws every prosecutor. And next time I go to the prosecutor convention, they're going to roast me as the third course. And they do. Anybody that is in criminal defense can tell you the stories of we have prosecutor conventions just like everybody else. They go to the convention and have the update section of the CLE, the continuing legal. And when the big cases come down, it's monumental because that's how the entire state prosecutorial arm learns. You guys used to do it like this. You can't anymore.
Right. Exactly. I mean, it's what make law. It's how law's made. It's like I'm always trying to explain to people. I'm like, look, a statute was, a House bill that made it through the Senate that got signed either by a governor, like a governor or a president. And at that point, that's when the argument starts because the application is when we're all fighting about how that law that has been written by a bunch of lawyers now applies in the real world. And, everything in what we do in terms of our profession is interpretation.
Yep.
You and I interpret shit very differently than prosecutors do in terms of how it applies.
Yeah, so much of that is the common law rulings that come out of these appellate decisions. Because guess what? The legislature ain't gonna write, and here, let's clear up your Fifth Amendment rights, make sure that everybody, no. It's gonna come out in a ruling that filters through the legal community eventually. Do you have a lawyer that reads the paper? Do you have a lawyer that hasn't paid attention to a case update in 20 years? Both of those lawyers exist. Then you're going to put it on to a judge who knows if the judge knows the most modern state of the law. Right. And from a sick market perspective, it's a market that perpetuates itself because there's always new developments. There's always changes that no one can be efficiently up to date with because the law is always changing and moving.
Exactly.
And this will now be known in Massachusetts as the Canone rule.
Right.
Literally, the Canone rule. Be sure you pull your jury extensively and ask them on the record before you issue a mistrial whether they've agreed to anything, blah, 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 blah.
Here, I'm going to pull this. Speaking of which, so I want to pull this up. So this is their rule, Crim Pro Rule 27 relating to the verdict, okay? So, and B is the one in question here. Okay. So we've got several offenses or defendants. So this says if there are two or more offenses or defendants tried together, the jury may, with there's your may, with the consent of the judge at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been reached. And thereafter, the jury may, in the discretion of the judge, resume deliberation. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may, there's that may again.
That may again.
Right. First, require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded.
So that rule basically says no matter what the judge did, they were right because everything's may and not required. The only requirement is that what the jury has to pay attention to the judge. So the judge has all the options in their hand to memorialize and establish any agreement from the jury and is expressly authorized to do that in that rule. But none of it's required. The way I read that, Canone was totally fine going, all right, you guys are done. I don't have to ask it all. Get out of here, which is basically what she did.
Which is exactly what she did.
Yeah,
exactly.
The promulgators of that rule certainly were like, but you can absolutely do this too.
Right.
You may do this, and then they're required to tell you. And I've had cases where you've mistried specific charges, where the jury comes back and says, listen, we're hung on this. Can you, and that is something that, you know, it's rare, but you mistried very specific charges. And it changes the case completely. Remember, if the main top counts, like here, are taken off are taken out of the sandbox, nobody can play with them anymore. You've now narrowed that scope, you've bracketed where the negotiations are going to happen, and that absolutely smooths the pathway to a consent resolution, which consent resolutions are the desired product of a contentious criminal justice system. The system was specifically designed to make two parties who are far apart so uncomfortable, scared, confident that they make an agreement.
Exactly.
That's the purpose, is to avoid trials.
Always.
And now what's happened, and Bob and I have to deal with this all the time, they've made trials so disagreeable, so expensive, so outrageous by providing additional tools to litigants to force each other to make deals that now trials are more rare than ever. And that's the real revolution in criminal justice. You
100%.
can't buy a trial in half the nation unless you are facing murder, rape, child molestation, terrorism. You can't buy a trial on a regular felony.
It's true. And so this is where it gets interesting. So the reporter's notes, and I want to read you this language because like when this was all going down, I tweeted Rule 27 in the reporter's notes. And
the reporters is the book of laws and decisions that we all get to go research when we have questions.
Exactly. It's not the rule. So I was trying to explain this to people. This is how the courts have interpreted the rule in the reporter's note. So it starts with the rule is patterned after Rule 31 of the Federal Rules of Criminal Procedure. Substantially, it reflects current Massachusetts practice as embodied in the common law and in statute. So subdivision B, this is where it gets interesting because like people, I kept trying to, like, it was one of those debates that you have on Twitter with people that they're like, that is the law. I'm like, no, it's not the rule. So, but it says this subdivision permits a jury in multiple defendant or multiple offense cases, which is the case here, with the consent of court to return a verdict at any time during their deliberations with respect to charges or defendants as to which a verdict has been reached. This rule also permits the court to require the return of such verdicts before the jury has reached a verdict as to all the defendants or charges.
Or judge flexibility in there. That's the judge flexibility.
Exactly. In either case, if the court directs the jury is to continue its deliberations after rendering the verdicts under the subdivision, to the extent that this rule permits the jury to return such verdicts without having reached a decision on all charges or defendants, it is consistent with Federal Rule Criminal Procedure 31BC. All right, so this is where it starts getting interesting. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, this is now here's your must. However, it must first receive and record the verdicts which the jury can agree upon. So like you've got this thing here where it's contradictory, where you've got may up top in the rule, and you've gotten the reporter's notes that's coming from the ABA standards, right? So that's where they drew that from. That, however, it must first receive and record the verdicts which the jury can agree upon. So, I mean, like when I was reading, I'm like, man, and I knew.
Roll up, go look. That draft is 1968. These aren't new things. Like when we devise trials and we're continuously refining our trial process, these issues have cropped. Hey, what do we do if they can only agree on this and not that? Oh, we should devise some guides and standards. And the American Bar Association has these grand committees from people all over the nation. They get together in their White Castles and eat hamburgers. And then they get around and make up a rule. And this rule very clearly, and you did an excellent job, must first receive and record the verdicts. That would make it appear that it is mandatory for the judge to inquire before the mistrial. Hey, y'all decide any of these?
Right.
Put a yay or nay on
simple question.
You think it would be really easy, and I've seen it, and you've seen it, and we've seen it on television, on Court TV, and some of these other networks where judges inquire when they're going through a mistrial process, because a mistrial represents the consumption with very little value received of enormous public cost.
Yes,
the trial cost is out of this world because you're combining multiple agencies, all spending huge amounts. So a mistrial, man, you just don't toss them out there. That's throwing out rocks that are bearing gold. Exactly. And so you should do something before throwing it out. And Judge Cannone didn't.
I think she was so enamored with the language in these notes by whoever the foreperson was drafting this prose that she just overestimated their knowledge in terms of what was going on back in that room. It's the only explanation. She's like, I've never read a note like this in all my years on the bench.
And I'll say, I think part of it has to do with the high profile of this puts judges in a different mental space than they are most of the rest of the time. Yes. And I see that's huge in YSL right now. I think that's huge in a lot of these high profile cases. The judges get nervous because guess what? Judges ain't that special.
Right.
It's like when you grow up and you believe doctors are like literally the Lord above has come down and made that person a doctor and they are in file. Sorry to tell you.
Yeah, they ain't.
With some doctors. I have some doctors that I can prescribe medicine, but shouldn't tie shoelaces or babysit children. Judges get nervous. And she's sitting there in the biggest case ever. And it's going wrong.
Yeah.
And rather than having a clerk come out there or a colleague go, hey, Bev, let's make sure you do all this right. Here's your checklist. Because judges have checklists by the buckets. They trade them on listservs. This is how you do this.
Right.
Rather than someone giving her a checklist of before you issue a mistrial, these are the 4 things you got to do as judge.
No doubt. You know she got that.
Know that the moment that night, some judge friend of hers, unsolicited, said, hey, just want to let you know, I noticed you didn't check to see if there's any verdicts. If they come out and say there was a verdict, you're going to have to deal with it. That's the kind of stuff judges talk about because they're keyed into a perspective of protecting a trial. And that's different from almost everybody because unless you've tried to protect a trial, you don't think like that.
Exactly. Like, and you're only in that position when you're sitting up on that bench. You know, I mean, it's one of their primary functions up there. And so what do you think she's going to do? Like, you've heard the arguments now. She's taken it under advisement. She didn't dismiss it offhand. So it gives you.
I believe that a retrial on counts 1 and 3 is untenable for too many reasons to count for all state agencies. That includes the court. That includes the local law enforcement. That includes the DA's office. finding the way to dispose of those with the least face, burnt off, with the least egg on the face. They can't ostensibly coordinate. There's not going to be a text stream between them being like, all right, who do we dump this off of? But they're definitely thinking about it. Judge Cannone does not want to diminish the legitimacy of the court system. It is very rare, if not unheard of, for judges to literally stand up and go, I boned that. That's just not in their DNA makeup. I believe that the problems in this case that we all know and are completely uncontrovertible lie with the insufficiency and problems with the investigation. Even on its best day, the Commonwealth cannot get away from some of the problems with the investigation. They can hang a lot of blame there for the problems in the case. I believe Lolly's boxed in. I've said for a long time, I almost pity Lolly because he has an undoable job. He has to craft a victory out of very few puzzle pieces. He does not have the fundamental materials to build a strong conviction case for what the state's told everybody she did.
Exactly.
But it ain't his fault. So,
and on top of that, he's got witnesses with warts that are.
We haven't even gotten into. All right, so you're gonna make Lolly a witness? Are you gonna really? You want to start throwing rocks? We can talk about changing the case entirely. You could even try to make Judge Cannone a witness in this, because guess what? She has information that would be necessary to be, explored, because you don't know what kind of conversation she may have had with her court staff that may or may not be something that may or may not be privileged, discoverable, or whatever. You can make a mess out of it all. And that consumption of resources. And when you're a defendant, you can pour fuel on the fire all day and drive nuts and eat them up, because guess what? Your job is to zealously defend your client.
Exactly.
One of the great parts about what we do. My job's in the damn Constitution. I don't have to go.
Literally,
it's in the Constitution.
Right.
My job is not help the state, help society, no. My job is to defend the hell out of someone from the overpowering weight of the state trying to take away their freedom. So I have a lot of room to throw wrenches, such as, since all these people were involved in this factual portion that relates specifically to the prosecution of this case, let's turn them all into witnesses. And if you want to have that trial, let's doing that in YSL. They're trying to make ADA Love and ADA Hilton witnesses. They're trying to make Judge Glanville a witness because it's really effective. But
super effective.
At the end, I think that Lolly goes back to his bosses and goes, all right, guys, we fight this. We're probably going to lose, certainly lose the court of public opinion, because we're trying to prosecute something where the jury has come back and said, don't prosecute these two charges.
Right.
They've got an obligation to act appropriate with charging choices. And if there's that much doubt, it would be hard to tell them that that's an efficient use of your time. And politically, these people got to get elected again.
Exactly.
Keep their jobs. And they do want to do the right thing. I know that the Karen Reed case is more polarized than really. I can't think of another one that's been more community.
Delphi.
Yeah.
Delphi is
I don't think Delphi gets there. I think that
close, man.
The unique circumstances with the blogosphere, with the unique characters, with the open access issues, with the national attention on this, especially as a deviation from politics. There's so many parallels to our political discussion and our true crime discussions right now.
100%.
I hope that Lolly and the Commonwealth realize when it is to cut and run and say, all right, we can nail her on this with what we've already got. And if you want to go to the end, man, there may be a couple years of prison if you really want to tag the trial tax onto her. I know most of those pleas might be straight probation, but this is different. And they could box her in and say, listen, you can get done with this and continue your life, or you can go through another 5 years, spend money you don't have to deal with all of this stuff, because the attention span of America is short. Yes. Give this case a year out of the spotlight, doesn't exist. We just had in Georgia a man die in his 80s. He was the lead guy behind the My Lai massacre. Now,
Wow.
you were alive in the late 60s or no history, early 70s. The My Lai massacre was the O.J. Simpson legal issue of the day. It was a completely unprovoked massacre of innocent civilians by military in Vietnam. And it was a beyond huge story because it was such a betrayal. That man had been living after all the justice was dispensed quietly, openly in nowhere, Georgia. Nobody even knew who he was.
Right.
He died. But for 3 years in the 70s, man, I bet his face was on every newspaper published. And that's what's going to happen here. Karen Reed in years, if she walks away with some slap and tickle, does not affect her, and that's something she should really consider.
And that's the $1 million question, though. Like from Morrissey and Lolly's position, are they too dug in because of the high profile nature? And that should never, ever work itself into the equation as far as they're concerned, but it does all the time. But are they so dug in on this shit? And is it in response to what the defense did in this case? And there's like, and I talk about it all the time. There's 2 cases out there wherein that I can remember wherein the defense laid out their entire theory. Both of those theories were third-party culprit theories, and they didn't just name people. They gave their entire theory of the defense early on in the case, and that's Delphi, and that's this case. And in those 2 cases, what you saw, especially in social media, which is the microcosm of our world, you saw 2 divided sides that were angry on both sides and adamant, as if either side actually knows the answer, which they don't.
But remember also, that's the job of good defense. And one of the learning experiences for me watching Delphi, watching Reed, watching YSL, watching Rust, and all these other big cases, the importance of that public narrative from the defense.
Yes.
Where historically the defense has had a very limited platform to say, hey, pay attention. Because the mainstream public old-fashioned media universe wasn't set up to give anybody accused of a crime a fair shake.
Exactly.
The lawyers didn't have access. The approach was always going to be, you've been charged, so you're probably guilty. A very standard establishment position. Now we have defendants who have successfully engaged either overtly or behind the scenes with a massive communications industry, bringing out their story. And some of it they can control, most of it they can't. But when you have division, does that benefit the state or the defense?
That's the question.
Yeah.
Like, I don't know. And like, for me,
on the optics.
Yeah, for me, I'm a huge fan of it. And as soon as it happened in both these cases, I'm like, look, like I've been waiting for this. I've been trying cases for 20 plus years, and to be in a position where we can finally pre-trial even the playing field to get the scales of justice equal.
A little bit more parity in there.
Yeah, you know what I mean? It's like
it ain't never fair, folks. You gotta understand. You show up in any, I don't care if you are a billionaire. You're showing up with a handgun. They've got a tank.
Exactly.
That's every single case.
That's
period.
It. Like I'm constantly talking about like our battle against the immense power of the government.
Idea what it's like to show up with your briefcase and your pen and a client and be like, oh no, that there's like 25,000 law enforcement employees in the state of Georgia. Right. They're all on the other side. Like you there is the David Goliath thing. It just fails to really make you feel. And that's what Karen's at. Watching how the media messaging outside really matters. That's been a great improvement for criminal justice in America.
It really has. It's taken a turn. You know, it's like it's gotten this thing where, you know, like when it started to happen, then the other side, the pro-prosecution side, started pushing this concept that people that are on social media, such as myself in Delphi, that I'm a lackey for the defense. I'm like, no, I'm a defense bar guy.
Yeah.
And I saw a guy's Sixth Amendment right to a fair trial and a speedy trial absolutely obliterated.
Obliterated.
I'm going to speak on it, and I'm going to come from a defense perspective, because what happened objectively is that his fundamental rights were destroyed.
And that's the shit that drives me nuts and this Brady discussion that we're having now fits right in. If I do that, if Bob does that, if we get caught hiding stuff, the hell you pay as a lawyer. Oh my, you get how dare you ruin the intent. Our system can't work without everybody having the ethics of sharing, and you stepped out of line and you do it in front of your client. They destroy your client-lawyer relationship, which they love doing. If you ever see a defense lawyer getting eaten alive by a judge in front of their client, it was only partly about what that lawyer may have may not done. Exactly. That's the state destroying the confidence in the attorney-client relationship in an unfair and pejorative manner. End of story, and it happens all the time.
Preach, brother.
Like that unfairness, it's just out there. And I love it when now people are getting out there, noticing the polarization and speaking out about it, being brave. When I was coming up, if a CIA agent, FBI agent, senior state said something, dude, who's going to disagree?
Right, it's gospel.
That guy's got a badge and a gun and he's got a license, and he's got impeaching law enforcement and state actors has grown so much. I now can
unbelievable.
And what do they do at the same time? They change the way they stack and charge people so that you're fucking nuts if you go up on trial. At least in Georgia, what they do is, so you committed a crime, they charge that crime 5, 7, 10 different ways. Exactly. So you can't, if the decision becomes plea or trial, if you take a plea, well, then they'll cut out most of those charges and you'll plead to 1 or 2 of them, and they have very much limited. But if you go to trial, you face all 5 or 10.
Exactly.
150 years. Every charge comes with 10, 20, 30 years. If you plead, no one gets it. But if you go to trial, hell yeah, you're getting a trial tax at the end.
Exactly. So they play the same shit here. Exact same shit.
And it becomes the stupidest friggin' negotiation where it's, hey, listen, they're willing to cut off all the charges but the aggravated assault, but you got to plead on the aggravated assault and do this. Now, if we choose to go to trial, they're going to charge you with aggravated assault plus 5 other horrific felonies, any one of which will plug you for longer than any plea I'm ever going to discuss with you.
No question.
And they've made it so that it is almost dumb.
Well, I try to explain to people, like, through my lives, that the way that they operate is they'll do that, where they'll just throw everything against the wall with the concept that, look, if you go to trial on this and lose, you're fucked. You're done. You're going away forever. Or in the alternative, what we're going to do is, if he pleads out, and this is a guy, like, I could have a guy who's just like, I didn't do this shit. Like,
I'm talking innocence. Yeah.
Right. And they come back with the offer that's a straight probation, where they're going to kick it down to like a class 4 with no jail time. That guy is typically going to take the offer, even though I'm telling them, like,
and they keep sweetening the pot. We used to have, you take a plea, it's on your, no, now you got first offender. That's got a million rules. Georgia has conditional discharge, which is first offender, but just for dope. And you got to use it in the right way. Exactly. Both of those are pleas in abatement, basically.
Exactly.
They take it. It's official. It's findable. It's a real thing. They file it. Everybody can find it. But if you do everything, and then at the end, if you're perfect, then they'll take it out of the drawer, tear it up, and you can tell everybody you've never been convicted.
Exactly.
That's a huge bonus. Huge for future. But if you screw up first offender in Georgia, they get to re-sentence you under the original.
Same in Illinois.
And they can light you up. We had a guy, the bow tie bandit, who would tell you, yeah, if you come back, I'm revoking every last day. And he would.
Oh, yeah.
And like, Judge, you just gave a guy 20 years on a couple of rocks of crack, and he's a judge. Well, he violated, and I told him I would. Now I had to. He's no longer a judge.
Thank God.
It's weird. But you see the unfairness, and the case that I tell everybody. I had a good old boy, North Georgia, mountain community, not one I go to all the time, and he got into an argument at a store during COVID about, no lie, wearing a mask inside a convenience store. I will admit, and so will he used some choice words against the proprietor, and those words were wrong. But he left. And then 2 or 3 hours later, the cops show up at his house out in the woods where he and his buddies are drinking around a campfire, having a good time. And the cops basically think it's going to be an easy walk and talk, disorderly cut. Well, my client decides he's not going to take it. And then there's an argument. And then so he ends up with like a dozen charges. And I tell him, man, we can win this because that's illegal. We can win that on him. You can't win the really easy shit. The obstruction. Guess what? Felony obstruction, it's a felony. You go to prison.
Right.
Yeah, we know no one actually gets felony obstruction. Well, unless you go to trial. And if you win 9 counts but end up pinned on obstruction, you got to do the max. You got to.
You're going in.
Judge I clerked for, one of the first trials I ever watched, guy had 2 charges, cocaine trafficking and false information to the police. During the trial, the defense smartly just ate the false information. Yep, we gave false information. Concentrated on the dope. Wins the dope. Of course, the jury convicts on the false information. And then the judge immediately gives him the maximum punishment allowable by law on an otherwise pointless ride-along misdemeanor. Because that's the way the system screws you.
That is how it works. Allie just came back. She had a federal case down in Florida. Our guy had gotten picked up coming in on a boat with 90 keys. So
green or white?
He's a white dude.
No. What was he? What 90 keys of what?
Oh yeah, blow, coke.
Okay, yeah. Because the weed cases now are very different.
Yeah, very different. So
coke and the Fenty, they like those.
She ended up she worked the government like a rented mule on that case. She ended up getting him 62 months
on that quantity,
on that weight. I was like,
and people understand when you get to sentencing in federal, it's the world's worst math problem. It's like they went to the worst elementary word problem teacher. We're like, devise the most complicated system for punishing people and then double its complexity.
Right. It really is.
There are books written on how to do sentence calculations, and even the authors are like, this is really hard. It's right. And these are not dumb people.
No. Well, I mean, the sentencing guidelines and federal shit, like it's insane. It's insane. Like literally, we're talking like tomes.
I pay somebody to do that for my clients because guess what? I don't have time. I can be really good at lots of stuff. You can't be an expert in everything. And it's
exactly
calculations in federal. You want someone who has done a trillion of them. They track the statistics. They keep up with the trends. There is more data analysis on federal sentencing than you would ever imagine, and it's unbelievably complicated.
Yep.
And again, it's set up because the market rules everything. Economic theories rule everything, including the marketplace of criminal justice. Criminal justice is a marketplace. There are inputs, there are stimulus, there are relationships that all work on market rules. And one of the key market rules is markets are going to be more efficient the more they operate.
Exactly.
And criminal justice is in a sick, twisted way becoming more efficient. But the way it does that is by cutting off the ragged edges where you find real justice, where you stop treating people as individuals and start going, all right, well, it's this kind of person with this kind of fact and this kind of fact, so therefore cookie cut. That's not the justice that I believe the Constitution promises, which is individual.
100%. Right. But, I mean, that's our battle, though, isn't it? Right. I mean, like every day of my entire career, I was in courtrooms or in a prosecutor's office trying to humanize an individual. like it's like 90% of the battle.
One of the key skills that we talk about, how do you become a good criminal defense attorney? You've got to be able to humanize. Because the law can carry you so far. The facts can carry you so far. If you can't take someone who has been trained and impressed by everybody you prosecute's basically subhuman, because otherwise, if you you considered them human beings like you'd quit being a prosecutor. You have to, in order to prosecute, you have to realize after this line, those are bad people who deserve punishment. And the easiest way for your own self-protection at that point, and it's a trap that every prosecutor,
Every one of them,
and is aware of, is you're dehumanizing these individuals. You're losing their uniqueness of creation that the Lord above has given every single breathing person in America, the uniqueness of creation. If you're going to be a successful prosecutor, you have to figure out how to ignore that,
right?
How to treat people as problems.
Exactly.
And your job that you get institutionalized in is forever. Hey, these aren't pieces of paper. These aren't people.
That's it. That's our job, man. That's what I'm saying.
This is just another cog. And I talk about it because it's like factory. And you've been at rocket dockets, high speed, efficient. You hear efficient court improving. That is taking away someone's value as a person
100%.
in exchange for speed and efficiency. We barely have first appearances anymore because we now figured out that at first appearance, you don't have any rights in Georgia. You get told what they're charging you with right now, which changes.
Yes.
It's not fixed. And you are told whether you can get a bond. That's really all they have to do. They don't have to give you a bond except on a few very specific things. And as soon as you don't require the courts to do something, you give them a may, they're going to take that may.
Yeah, big
and
time.
Now in Fulton County, unless you go hire a private lawyer, you get arrested on a felony, you do 90 days because that's the earliest you're going to get a bond hearing. And people like, Josh, 90 days. And I go, well, they're so slow they can't actually bring them to trial. They can't. So the only value the state can get is 90 days of guaranteed incarceration before they have to, under law, give them a bond. So they give that 90 days to everybody.
So like in Illinois, they passed the no bond statutes, which means that like you go in where they're not going to give a bond. Right. Everyone's going to get out. But what they're doing is like we just had a client who first offense, fleeing and eluding, and they gave him a bond. Like I'm like, wait a second. I'm like, so that's what the move is going to be. So like on some bullshit first offense, you're going to say, okay, we're going to give you a $10,000 bond, 10% to apply. That's it. I'm like, wait a second. Like that shit's supposed to be like for the murderers and the rapists, not for this bullshit. I'm like, so that's how you're going to battle it from inside the courtrooms by just, and really until it starts getting appealed, and that's one of the issues that we can appeal interlocutory, but like, who's going to spend the fucking money?
And that's exactly the worst abuses that people never, when they hear about these really horrible things that happen, you don't get to appeals. Why? The state knows that that's an exposure to them. They're never getting that close to it. You find a prosecutor who did something really abhorrent, they're going to find a way to bury that in a plea or a reduction that saves their face. There's a big case in Georgia where the judge, my former judge, commented on a guy's gold teeth, and it was super racist and super. They're still dealing with it like 15 years later.
Yeah.
And what are they doing? Repleading the kids.
Yeah.
Because then they don't get rulings. Or in Georgia, they will issue an opinion and they'll call it a slip opinion, non-binding. It's like, hold on, I thought that appeals were for like No. We're making this rule for this case under this factual circumstance. We're not even going to put it in the book. No one can find this unless they know to look for it. So it's not precedential, but we're still going to do that. And it's like, man, that's not how this shit works.
It's not how it is.
It's good for everyone.
Exactly. At least in theory. It's like the same shit that I've been dealing with and that you've been dealing with. It's for 20 years trying to get the state to acknowledge that mental illness and or addiction is the impetus of probably 90% of the crimes that are committed is an impossible task, man.
Yet every highfalutin establishment person that does something unbelievably steals huge amounts of the embezzlement that we see. Oh my God, you'd be amazed at how many fine, upstanding people are just thieves.
Yep.
Every one of them, I know I can get them to walk. I know how to do those cases. I do lots of them. You steal and have money to pay me, I'm going to get you a great result.
Right.
But the regular Joe and Jane, when you get out of these big money things, they get hosed every time. They can't bring in my shrinks. They can't bring in my experts. And you're absolutely right. Substance abuse, mental health, those are the concurrent comorbidities that drive 90, 80% of all arrests in
all
America.
arrests, all of them. And it's like
we treat that as a health problem rather than a criminal. Now, if you really want to get deep, and I got to get off of here in a minute, it's almost 4, but if you go find out why the mental health is like that, it goes back to the 1920s. There was a split in psychology as it was forming as a discourse in the United States. There was the treatment method that was brought about by Freud and the psychoanalysts, which is once a problem manifests, we can treat it. You come in, you do therapy, you do and that's how most psychology formed in the West. There was an alternative set of doctors named the Meningers that were based out of Kansas, and the family hospitals now in Texas, huge mental health.
Yep.
The Meningers wrote a series of books saying, whoa. We agree this is how mental health needs to be categorized, and these are great treatments. Really, instead of treating it after it manifests, you need to get in front of it because you can see these issues when they are children, when people are in development, far more efficient and healthy to note early and intervene. Problem is you can't bill for that.
Exactly.
The business model of mental health became when there's a problem, I'll solve it, rather than, hey, everybody has a likelihood of problems. Let's get out there, and as soon as anyone starts popping up, let's go fix that.
Exactly. Let's get in front of it. Yeah, that shit.
Doesn't make money. You can go read the books from the 20s and 30s. The only reason I know that is my family's been in psychology since then. But really, that's how we got to this treatment method. And when mental health, which slowly is getting more recognition, but it is slowly.
Oh my God. Like our elected, like kind of the primary county that we practice in, she ran on a platform of, I'm going to acknowledge mental health. I am going to create a mental health court.
Yep.
And we're like, holy shit. I'm like, hey, like, if this is a prosecutor, I'm like, I'm not going to put your fucking yard sign in my front lawn because I've been waiting for 20 years to hear one prosecutor say that. And then she did. And then she came in and she actually did what she said she was going to do. She's handled cases where she's acknowledging that there's mental health issues and that they were pre-existing and that they were the cause of the crime. And I'm like,
it took in Georgia, it took the unbelievably powerful and long-serving Speaker of the House to have a mentally ill family member. That's how we got her.
There you go. There you go.
It wasn't like a son or a daughter. It was like a cousin or someone close enough that it was clearly their fit. And they went through absolute hell in red gas. And did jail, got locked up, had to deal with a system that's complex for smart lawyers, let alone mentally ill people who didn't get community support and education. And that was how we started getting mental health reform. Now, of course, that poor guy died. And what are they doing? Trying to take away the mental health reform. Eventually, we will get there.
We will. Maybe, I don't know if it'll be in my lifetime.
The cost savings of social workers and medical providers on the outside, monitoring, low impact people living on their own with guard, that is so much cheaper than locking people up in a dank, dark cage where they're victimized. And God forbid, you ain't burning in hell for wrongfully giving someone medical access as opposed to locking them away and destroying. I get the fear thing.
Yeah.
People are afraid of people that they don't know, that they're unfamiliar, that they don't understand. Don't be motivated by fear. Right. Be motivated by the good. We are so much better together working positively and upward facing than downward facing. You cannot out arrest yourselves of violent crime, drug addiction, and mental health. Because guess what? That schizophrenic doesn't care about your policy goals.
It doesn't give a shit.
They're going to take dope until they feel better.
Exactly.
And then if you give them some real legitimate pharmaceutical dope, but you only give them 2 weeks worth, then you make them go jump through a bunch of the schizophrenic guy ain't going to do that.
Exactly. Or that schizophrenic guy that's being just doped up for 2 years and who finally gets to the point where like, shit, I feel better, but I hate the way that I feel on my meds. I'm done taking that shit. and then the cycle starts again. You know,
every one of those truly horrific random murders, like we all hear about from New York City, where it's some nice lady gets thrown onto the track, those ones where it's just terrifying. Every one of those is untreated or undertreated.
Always.
Every single.
Always.
That
Dude, I love you, man.
And shit, Jesus, you can save lives, but we don't want to pay for that shit because it's way more fun to buy guns and tanks and jails and that shit because it satisfies the loudest, scaredest people.
Yep.
People, be positive. You are created for good. There's bad out there in the world. The light will drive it away. But be good. Do good things. Don't concentrate on punishment and shutting down. Welcome the growth. Talk to
me, dude. You're like trying to change that mindset. Like you and I are voices out here. And if y'all love Josh, make sure you're following him on his Twitter account, which is amazing, or X, whatever you want to call it. But a great
account. I love people to do that. Really.
Yeah. Like everybody on here, if you're on X, go follow him immediately. Josh, like you're an amazing guy. You're a fucking brilliant guy. I've been waiting to hang with you for a long time. We
got to do this again. We got to make this regular.
You got a standing invite. You got a standing invite over here, brother. And you're on Court TV 3-4 times a week.
Yeah.
All of our people love you, man. You're the truth. I adore you. I love hanging. I appreciate you coming today. Have yourself an amazing weekend. You got anything you want to plug?
No, man, just go out there and be good people and be good citizens and educate yourself and know what you're talking about. And really, be good people. It ain't that hard, man.
That hard.
Go out there. Don't screw people. We all have the same common fundamentals built into us. It is chemical. It is creation, whatever you want to call it. Go concentrate on that.
Yeah, man.
Be good to your fellows.
Preach, brother. Preach. You're the best, dude. All right. Have an amazing weekend, man.
Talk to you
later. Bye. So he's the best. It was great to hang with him. He'll be back. I assure you that. I'll be up in his DMs, like hitting him up to join us. So interesting day. We'll see how it plays out. I have no idea how long Judge Bev will take to rule on this thing. And I'm interested to find out the way she comes down on it. It should be interesting. It's going to be an amazing set of circumstances, no matter which way it comes down. If it comes down what I'd consider to be the wrong way, where she's like, you know what, I'm going to kick it on a waiver. I'm not going to deal with it. I think that's the wrong approach. But the other approach is slippery. You know, it's a very slippery slope in terms of saying I'm bringing those jurors back in. I'm going to have discussions with them. It's going to be really, really interesting either way. So you guys, mods, I love you guys. Thank you so much. I have portaled everybody to Jay's live tonight. He's got our other favorite, Josh Ritter is joining him tonight. They're going to be talking Adelson, digging into some testimony. That's going to be a great live. So you don't have to do anything. I portaled you over there. When that thing starts, I think it's 8 Eastern, 7 Central, I believe. Don't quote me on that, but I think that's when it is. So you guys make sure you're checking that out. I'm sure I'll hang out in the chat a little bit if I can get my Garcia episode recorded, which is what I'm doing as soon as I get off the stream. All of you guys out there, I love you, our family. Thank you for hanging. My mods, you're the best in the business. You guys are unbelievable. You are there through thick and thin, and I adore you and appreciate you more than you'll ever know. And to all of you out there that join us every time we come live, we adore you guys. You guys really do make this worthwhile. You make it a joy for me to do this. I love reading the chat. I love hanging with y'all as much as I can. So thank you guys. If you didn't on the way in, make sure you like, share, subscribe, get us out to the ether, help the show grow. Thank you for everybody that contributed and gave out memberships and threw us some cash. We really appreciate that too. It's how we sustain. So just know that every little bit counts, and we feel every single one of you that ever kicks us a little cash. We feel it deep in our hearts. So thank you guys. Love you guys. See you on Jay's stream tonight. Have a good weekend.